Welcome back. Wow. Now, the more the trial of the leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanu, lasts, the more twists are introduced. Kanu has sued the Chief Judge of the Federal High Court, Justice John Toshon, and the Chief Registrar over the new practice on hearing terrorism cases. This followed directive by Justice Toshon that terrorism trials, including the ongoing trial of Kanu, be done secretly, even without journalists, except the judge's rules otherwise. Jide, this is a new trend.
Actually, the Constitution permits the Justice Soho, who is the president of the court, to take this kind of decision if he's convinced that it is in the best interest of the court and even the person on trial. If he's convinced that security could be breached or whatever, in Section 36 of Section 4 and 3B of the Constitution, the judge is permitted to take that kind of decision. You know? So, because it says, subsection B says, if any proceedings before a court or such a tribunal, a minister or commissioner satisfies the court that it will not be in the public interest for any matter to be publicly disclosed, the court shall make arrangements for evidence relating to the matter to be heard in private. That is the provision. Now, in this case, it is not Kanu's matter alone. Remember the matter of the so-called sponsors of Boko Haram. They are also due to go on trial. There are some facts that will come out of that particular trial that they will not want the media or the public to be privy to. So perhaps that also played a part. But the Nigerians deserve to witness the trial and see the way the trial went, because we've even seen situations in which lawyers came out of the court, journalists went to interview them, and they gave the wrong interpretation of what transpired.
Several times.
Yes. A lawyer gives
something to suit himself.
Something that suits his own. So remember even the case of the Abia governor, when one of the famous lawyers was even calling you names. And we said on this program that this was the way this matter went. And we were more than vindicated. So sometimes lawyers can mislead the public for their own, for reasons best known to them. So in my view, it is still best for journalists to be allowed to witness this kind of trial, see the way everything is going, and be able to affirm whether fair trial, whether the person got fair trial or not. But again, as I said earlier, nothing precludes the president of the court, Justice Soho, from taking the decision that he has taken. The Constitution talks about that in Section 36, subsection 4, that there are conditions that can make a judge decide that, look, this trial must not be held in public because certain information must not filter out. So what Kanu's lawyers believe that for them, the purpose of fair hearing will be best served if people are allowed to cover the trial itself. So they are trying to get an order of the court to set aside the decision of Justice Soho.
Looking at the public interests and looking at the people involved in this trial and everybody, if you see the turnouts in courts where they started the trial and the number of people, the kind of people that came out to, witness the trial of Nnamdi Kanu, and The Southeast, they've even declared any day that is in court, that day should be sit at home. Do you think this is not going to further fuel the distrust on ground?
So, well, I think at this particular point in time, we have to take a closer look at what is defined as the national interest and the public interest. At any point in time, where the public interest or private interest collide with the national interest, everybody knows that the national interest takes precedence. But because of the nature of the trial of Kanu, it has dragged on for so long. And it will appear as if the lawyers, it is in the interest of the lawyers. It is also in the interest of the litigant himself to prolong the trial. If they prolong the trial, the interest of the state, that is the government, will not be served. Because right now, the whole of the Southeast is still under lock and key any day that Kanu is brought to court for trial.
Even the Mondays, they've not been able to rescue the Monday.
Even the new governor, in spite of the fact that the governor Soludo has tried his possible to ask people to suspend that thing, it has not been suspended. Even the people themselves, they are not ready to even listen to the governor, or that, in spite of the fact that they voted him into power. So I think that even the judiciary itself has to find a nexus between the national interest and the public interest, especially in specific cases like this that has generated international attention. And looking at the fact that we have to do something to stop the carnage in the Southeast. We have to do something to ensure, to allow people to know that justice is going to be served. If bending the rules means that journalists should be allowed to cover that thing, not to give them, and like Gide said, we know lawyers in Nigeria, they are there to defend their clients' interests and their own personal professional interests too. And by that, they can mislead the public. So there must be a way in which we have to sort this thing out so that the interest of the public has to be taken into consideration.
You know, if you remember when this trial started, if you remember, there was a list that came out. The DSS accredited TV and newspaper houses. I remember our correspondent Celestina that showed me a copy, as in those. It's not even all media houses that were permitted, but at the point in time they started having security challenges. Even during the trial, the number of people that want to access the court and everything, so it could go. Do you think security might have come into consideration for this judge to have granted this order?
No, and as I said, it's not Kanu's matter alone that prompted this decision, because they are talking about terrorism, trial of terror suspects and all that. They didn't say Kanu alone. There are other terror suspects that are in the mix. So in this case, yes, on the first day they brought him to court, they almost lost control of things. But these days, it's no longer like that. Some of those scenes, unpleasant scenes that we saw on the first day that he was arraigned, we no longer see those things. The DSS have handled the situation a lot better. But the law says that they can exclude they can exclude individuals apart from the litigant, apart from the person being put on trial. The law permits them to exclude some individuals from witnessing the proceedings. So it is this law that Justice Soho has effectively invoked just to ensure that the trial of Nnamdi Kanu and other people, especially the Boko Haram, so-called Boko Haram sponsors, the media does not have access to it. But I still think that the media needs to be allowed to cover this court proceedings, not to completely put a kind of blanket ban.
I trust it to be challenged, and we know the outcome.
So the case Kanu has challenged, and the interesting thing is Kanu has brought up all kinds of Kanu's lawyers are challenging the federal government at every turn.
Seems to have
he won
all the cases.
He won a case in Abia the other
even
day,
the number of charges
over the storming of his father's house. He won that one. We have not appealed. The rate at which things are going, maybe we will not appeal it. Then we also sued them for bringing him from Kenya forcibly. That case is still there. Really? Now we have this one. So it's not simply folding his arm, waiting for judgment to come in this matter. He's also simultaneously suing the federal government on different this thing.